Call the meeting to order. Have a motion to adopt the agenda.
I'll make a motion to adopt.
I'll second.
All in favor?
Aye.
Do we have any public comment?
Not for regular meetings, no sir.
Have a motion to open the public hearing for case 202-6010.
Make a motion to open case 202-6010.
Second.
All in favor?
Aye.
Do you wanna go ahead and you start and then I'll.
Yeah. This hearing will be conducted by the Planning and Zoning Board, also serving as the Board of Adjustments. My name is Carter Burns, and I'm the Chair of the Board of Adjustments. Would the board members please go around and state their name for the record?
Jeannie Russell.
Tom Bean Blossom.
Kenny Small.
Attorney Misty Whitman will be advising the board on legal and procedural questions. Angel Jenkins, the Town Manager and Zoning Officer, is serving as staff to the board today. If you wish to speak as a witness today, you can find the sign-up sheet at the podium.
Does anybody want to speak for or against? Okay, I'll just pass it around if that's okay.
No, this case is.
This one is for, Bombay Road, so,
For what?
if you're gonna speak at all for either one, you
Oh,
can
okay.
sign up. And then we'll just ask whoever's speaking for those. We'll take just a minute and let you guys sign up. Could've done that while we were waiting, I apologize. Do you guys wanna speak either way? Okay. Y'all can speak, okay. Hey, Angie. Yeah, I have two copies. Oh, the same one? Ms. Boyd, what's your address?
822 Old Town Road.
Special use permit 202-6010, request by Wilson and Melanie Rowe for a special use permit to place a Class A manufactured home on their parcel located at 639 Bombay Road. This parcel is in the RA zoning district. The public hearing is for special use permit case number 202-6010. Applicant Wilson and Melanie Rowe. Parcel number 070420000016B. PIN 6678-03-59-7181. The decision will be made by 4/5 vote of the board. This hearing is a quasi-judicial evidentiary hearing. That means it is like a court hearing. State law sets specific procedures and rules concerning how this board must make its decision. These rules are different from other types of land use decisions like rezoning cases. The board's discretion is limited. The board must base its decision upon competent, relevant, and substantial evidence in the record. The quasi-judicial decision is not a popularity contest. It is a decision constrained by the standards in the ordinance and based on the facts presented. If you will be speaking as a witness, please focus on the facts and standards, not personal preference or opinion. Participation is limited. This meeting is open to the public and everyone is welcome to watch. Parties with standing have rights to participate fully. Parties may present evidence, call witnesses, and make legal arguments. Parties are limited to the applicant, the local government, and individuals who can show they will suffer special damages. Other individuals may serve as witnesses when called by the board. General witness testimony is limited to facts, not opinions. For certain topics, this board needs to hear opinion testimony from expert witnesses. These topics include projections about impacts on property values and projections about impacts of increased traffic. Individuals providing experts' opinion must be qualified as experts and provide factual evidence upon which they base their expert opinion. Witnesses must swear or affirm their testimony. At this time, we will administer the oath for all individuals who intend to provide witness testimony.
Do we have anybody that's testifying other than who's speaking, Angel, on this one?
Do you want the landowners to?
If they're going to. Left hand on and raise your right. Left hand on and raise your right.
Yeah, the other right.
Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay.
As a reminder, witnesses should provide factual testimony as to how this project does or does not meet the standards. The board must base its decision upon evidence in the record, not personal preference or opinion. Please be aware that the applicant and other parties have certain rights to object to your testimony and cross-examine you as a witness. The board, though, will determine what evidence to consider and how much weight to assign to it. Moving to the disclosure, or anybody?
Yes.
Okay. The parties to this case are entitled to an impartial board. A board member may not participate in this hearing if she or he has a fixed opinion about the matter, financial interest in the outcome of the matter, or a close relationship with an affected person. Does any board member have any partiality to disclose and recusal to offer? We will now proceed to ex parte communication. The parties to this case have rights for an ex parte communication to be disclosed. Ex parte communication is any communication about the case outside of the hearing. That may include site visits as well as conversations with parties, staff, and the general public. Does any board member have any site visits to disclose? Does any board member have any conversations or other communications to disclose? We will now proceed with the hearing. Ms. Jenkins will read the application, giving the summary, and introduce the applicant.
Thank you. Thank you guys for being here tonight. So we have received an application for a special use permit from Wilson and Melanie Rowe. Property address is 639 Bombay Road, and the special use permit is for them to be able to place a manufactured Class A double wide home on this parcel. It is within the town's ETJ. Property is zoned RA, and by ordinance, they have to have a special use permit in order to do so. I provided you guys with the definition by the zoning ordinance for what a manufactured home is, and it also has the requirements that once the house is placed, what the requirements are. Class A manufactured home, commonly referred to as a double wide, is a multi-sectional manufactured home constructed after July the 1st, 1976. That means all of the meets or exceeds the construction standards. And there are some stipulations that manufactured home has a length not exceeding 4 times its width, with length measured along the longest axis and widest measured at the narrowest part of its axis. The manufactured home has a minimum of 1,200 square feet of the enclosed heated living area. Pitch on the roof of the manufactured home has a minimal vertical rise of 3 1/2 feet for every 12 feet of horizontal run. And all roof structures shall provide an E projection of no less than 6 inches and may include a gutter. The exterior siding consists predominantly of vinyl or aluminum, horizontal lap siding, wood, hardboard comparable in composition, appearance, and durability to the exterior siding commonly used in a standard residential construction. A manufactured home is also set up in accordance with the standards of North Carolina Department of Insurance. Stairs, porches, entrance, platforms, ramps, and other means of entrance and exit to and from the home shall be installed or constructed in accordance with the standards of North Carolina Department of Insurance and attached firmly to the primary structure and anchored securely to the ground. The moving hitch, wheels, and axis and transporting lights, sorry y'all, tongue tied tonight, have been removed, and a continuous permanent masonry curtain wall or foundation, unpierced except for ventilation and access, is installed under the manufactured home. It is an intent of this criteria to ensure that the Class A manufactured home, when installed, shall be substantially the appearance of an on-site conventionally built single-family dwelling. It is staff's recommendation that this purpose, home type, and consistency with the ordinance definition of a Class A manufactured home is located within a residential agricultural district, which does allow for a Class A manufactured home. The appearance standards ensure compatibility with the surrounding residential development, and there is no adverse impacts on the public health and safety with you guys getting a special use permit. So it is my recommendation that you do approve this. The Rowes have provided information on their lot. It is located, it's a subdivision off of a larger parcel that was given, has been platted and registered at Davidson County. And then there's a diagram of their house, floor plan, and what it looks like. And Mr. and Ms. Rowe are both here. If you guys have any questions, I'll have them come up and you can direct them.
Hello.
Hello.
Do you have any questions?
Did you say this was part of the subdivision?
No, it was a parcel that has been subdivided off of a larger
I
parcel.
thought she said subdivision.
I didn't
No,
know.
it was subdivided off of
Okay.
It sounded
a
like
larger.
divisions, to be honest. I thought that too.
It's just for one house.
This piece was divided out, correct?
Yes. Anybody have any questions?
Any questions? Do we have anyone wanting to speak for or against a special use permit?
Is there any setbacks required in that, Angel, as far as off the road?
It'll be based on the RA standards. The zoning's not gonna change.
Okay.
So,
It has to be at least 40.
yeah, 40 foot in the front, and then the sides are 15, and the rear is 10. So they've got plenty of space. Mr. Hunt actually came to us and talked to me about it before they did the parcel division, so that
Okay.
way they knew what was needed and required.
Good deal.
Mr. and Ms. Rowe, do you have anything further you wanna add or include? Does the board have any further questions? Do any of the board members see a need for a condition or conditions be placed upon applicant in the event the application is granted? And what such condition or conditions might that be? The board has now received all evidence and testimony. The hearing is now closed, and the board must consider the evidence and vote on the matter. Board members, does any board member wish to discuss what we have heard and received? If the board has no further questions or need for discussion, we must now begin the voting process on the findings standards. As a reminder to the board and those in attendance, North Carolina general statutes and our town zoning ordinance requires a 4/5 majority vote in the favor of the applicant on all 5 standards. In order for the applicant's special use permit request to be approved, we have 4 voting members in attendance. Successful motion on each standard requires at least 4 affirmative votes. Standard 1. With regard to standard number 1, the use will not materially endanger the public health or safety if located where proposed and developed according to the plan as submitted and approved. May I have a motion to approve or deny standard 1?
I'll make a motion to approve standard 1.
Do I have a second?
I'll second.
Any need for further discussion? All in favor? Aye. The ayes have it, 4-0. Standard 2, with regard to standard 2, the use meets all required conditions and specifications of the permit. May I have a motion to approve or deny standard number 2?
And when you actually do this, will you read evidence in, because you need these findings of facts in the record? So I think you've got findings of facts set forth here, so if you can find those findings of facts.
Which one?
These right here on the,
No.
Whoever makes the motion can actually say, you know, I make the motion that we approve it and that it meets all required conditions and specifications as set forth under this evidence, minimum of 1,200 square feet, et cetera, et cetera.
Okay. So may I have a motion to approve or deny standard 2?
I'll make a motion to approve standard 2 as it meets all the required conditions, specifications, the ordinance of, and specify those out, Misty. Minimum 1,200 square feet. So a roof pitch of 3.5 to 12. 6-inch E projection, exterior siding comparable to site-built homes. Removal hitch, wheels, axles, and transport lights. Installation of continuous permanent masonry curtain wall. And is in compliance with North Carolina Department. Who is DOI?
Part of insurance.
Department of Insurance setup standards.
Do I have a second?
I'll second.
Any need for further discussion? All in favor? Aye. Standard number 2 pass, a vote of 4-0. With regard to standard number 3, the use will not substantially injure the value of adjoining or abutting property, or the use is a public necessity. May I have a motion to approve or deny standard number 3?
I'll make a motion to approve standard number 3 with will not substantially injure value of adjoining property. Use of public necessity as a Class A homes are designated to resemble the site dwellings, and masonry underpinning and residential grade materials reduce visual impact.
Do I have a second?
I'll second.
Any need for further discussion? All in favor? Aye.
Aye.
Standard number 3 passes with a vote 4-0. With regard to standard number 4, the location and character of the use, if developed according to the plan as submitted and approved, will be in harmony with the area in which it is to be located and in general conformity and with the plan of development of the town and its environs.
And if I may, on this one, the motion should just read RA for the conditions
Okay.
instead of R8. My apologies on that.
May I have a motion to approve or deny standard number 4?
So we'd skip the second one, Angel?
Yeah, just don't put all
Okay,
right.
okay. I'll make a motion to accept the location and character will be in use harmony with area and general conformity of town's plans. Class A manufactured homes are permitted special use permit in RA areas. district allows single-family residential issues and appearance standards, ensure compatibility with surrounding homes.
Do I have a second?
I'll second.
Any need for further discussion? All in favor? Aye.
Aye.
Standard number 4 will pass with a vote of 4-0. After voting on all 5 standards for the special use permit request, the board approved general standard number 1 with a vote 4-0, approved general standard number 2 with a vote 4-0, approved general standard number 3 with a vote 4-0, approved general standard number 4 with a vote 4-0. Where all 4 standards approve in favor of the applicant, so from a review of the votes of the board, all 5 standards were approved in favor of the applicant, and as such, in accordance with our zoning ordinance and North Carolina law, we must approve the special use permit request. Do I have a motion for approval of the special use permit request by the applicant?
I motion we approve the special use permit by the applicant.
Do I have a second?
I'll second.
All in favor? So the special use permit will pass with a vote of 4-0. Throw me off.
Only Gary, you do that.
No, you can just, when you're talking, just say.
Butts up. That Angel.
Yeah, just let you know up front.
We won't have one.
We won't have a vote. I got a few from stuff on this one. I'll copy those up too. No, yeah, that's one that you don't have to.
And this one's, a contingency sale. That's what it's putting on.
Yeah, back front up to me.
Well, can we,
No,
can we,
not that one.
It does.
No, it doesn't.
She says it doesn't see.
I don't know what you're saying.
The reason I say that is because it's again, it's a division of that property. It's not the full parcel.
That 9 acres backs up to me, I'm pretty sure.
It's not the 9 acres that they're asking for this,
I thought it said 9 acres.
I have my map.
If it don't, it's good. If it does, I got that.
So this is the original, go to the next one. There should be, a map.
it's on that 1.5 acres.
Then I still think that's up to me. Still should have something.
The 9 acres does, but it's this portion here. So this portion does not butt up to yours.
You sure?
I'm absolutely sure.
Okay, where are you?
He's
You can't see mine.
He's over here. This is the original parcel,
Yeah, but I'm still in two.
but this
Yeah,
is
but
what,
only this piece right here, and you don't touch that piece. Okay, so we're gonna go, they can't see because they're not here,
right,
but we can continue on with here.
Okay. All right.
Okay.
I thought it was the other part.
In the rear portion.
Yeah, that's what I said. That's why I was thinking how to. Yeah, but said no, I'm good.
I do.
already sworn, I don't have to re-swear
Not
you. Is there
me.
anybody else here I need to swear?
If anybody, you're gonna speak and, okay, yeah,
Okay,
we've
so
got
one
two.
more.
Okay.
Now,
Do they need to, he needs to go back through the whole.
Yeah.
Yeah.
Gotcha.
You're reading the disclosure now. Yes, we got you.
yeah, starting from all of this, going back. We're gonna have a quasi judicial evidentiary hearing. The hearing will be conducted by the Planning and Zoning Board, also serving as the Board of Adjustments. My name is Carter Burns, and I am the Chair of the Board of Adjustments. Would the board members please go around and state their names for the record?
Jeannie Russell.
Tom Bean Blossom.
Kenny Small.
Attorney Misty Whitman will be advising the board on legal and procedural questions. Angel Jenkins, Town Manager and Zoning Officer, is serving as staff to the board today. If you wish to speak as a witness today, you can find the sign-up sheet at the podium. Special use permit 2026014, request by Ian Klotz and Cali Klotz for a special use permit to place a Class A manufactured home on their parcel located at Sturdivant Road. This parcel is in the RA zoning district. We'll now open the public hearing. This public hearing is for special use permit, case number 2026014, applicant Ian Klotz and Cali Klotz, parcel numbers 070380000022D, pin 6669-04-60-8227. The decision will be made by 4/5 vote of the board. This hearing is a quasi-judicial evidentiary hearing. That means it is like a court hearing. State law sets specific procedures and rules concerning how this board must make its decision. These rules are different from other types of land use decisions like rezoning cases. The board's discretion is limited. The board must base its decision upon competent, relevant, and substantial evidence in the record. A quasi-judicial decision is not a popularity contest. It is a decision constrained by the standards and the ordinance and based on the facts presented. If you will be speaking as a witness, please focus on the facts and standards, not personal preference or opinion. Participation is limited. This meeting is open to the public and everyone is welcome to watch. Parties withstanding have rights to participate fully. Parties may present evidence, call witnesses, and make legal arguments. Parties are limited to the applicant, local government, and individuals who show they will suffer special damages. Other individuals may serve as witnesses when called by the board. General witness testimony is limited to facts, not opinions. For certain topics, this board needs to hear opinion testimony from expert witnesses. These topics include projections about impacts on property values and projections about impacts of increased traffic. Individuals providing expert opinion must be qualified as experts and provide factual evidence upon which they base their expert opinion. Witnesses must swear or affirm their testimony. At this time, we administer the oath for all individuals who intend to provide witness testimony. As a reminder, witnesses should provide factual testimony as to how this project does or does not meet the standards. The board must base its decision upon evidence in the record, not personal preference or opinion. Please be aware that the applicant and other parties have certain rights to object to your testimony and cross-examine you as a witness. The board, though, will determine what evidence to consider and how much weight to assign to it. Witnesses must swear or affirm their testimony. At this time, we will administer the oath for all individuals who intend to provide witness testimony.
Everyone come forward that I need to swear in. And then you'll have to make sure they have standing whenever they need to speak, okay? Left hand on, raise your right. You guys wanna come up? Okay. Do you swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, thank you. And Angel, just reminding you, you're still sworn in.
The parties to this case are entitled to an impartial board. A board member may not participate in this hearing if she or he has a fixed opinion about the matter, financial interest in the outcome of the matter, or a close relationship with an affected person. Does any board member have any partiality to disclose or recusal to offer?
No.
The parties in this case have rights to an ex parte communication to be disclosed. Ex parte communication is any communication about the case outside of the hearing. That may include site visits as well as conversations with party staff or the general public. Does any board member have any site visits to disclose? Does any board member have any conversations or other communications to disclose? Ms. Jenkins will read the application, giving a summary and introduce the applicant.
Thank you guys again. So the application comes to us, the property owners are Brianna and Zach Collins, and the applicant is Ian Klotz and Cali Klotz. And, they are requesting a special use permit in order to place a Class A manufactured home, otherwise known as a double wide, on a parcel located within the town's ETJ. The property is zoned RA, where the Class A manufactured homes are permitted by special use permit only. Definition by our ordinance states that a manufactured home is a structure that's transportable in one or more sections, which in the traveling mode is 8 feet or more in width and 40 feet or more in length, and when erected on site is 320 or more square feet, and which is built on a permanent chassis designed to be used as a dwelling with or without a permanent foundation. When connected to the required utilities and including the plumbing, heating, and air and electrical system contained therein. Class A manufactured homes, commonly referred to as a double wide, a multi-sectional manufactured home constructed after July the 1st, 1976, that meets or exceeds the construction standards promulgated by the U.S. Department of Housing and Urban Development, and that were in effect at the time of the construction, and that satisfies the following criteria. The manufactured home has a length not exceeding 4 times its width, with the length measured along its longest axle, and with the width measured as the narrowest part of the other axles. The manufactured home has a minimum square feet of 1,200. The pitch of the roof is, the manufactured home has a minimum vertical rise of 3.5 feet for each 12 feet of horizontal run, and the roof is finished with a type of shingle that is commonly used in standard residential construction. A roof structure shall provide an eave projection of no less than 6 feet, which may include a gutter. The exterior siding consists predominantly of vinyl or aluminum horizontal lapping siding whose reflectively does not exceed that of a flat white paint, wood, cardboard comparable in composition, appearance, durability, or the exterior siding commonly used in standard residential construction. A manufactured home is set up in accordance with the standards set by the North Carolina Department of Insurance. Stairs, porches, entrance platforms, ramps, and other means of entrance and exit to and from the home shall be installed or constructed in accordance to the standards of the North Carolina Department of Insurance and attached firmly to the primary structure and anchored securely to the ground. The moving hitch, wheels, and axle and transporting lights have been removed, and a continuous permanent masonry, curtain, wall, or foundation unpierced except for ventilation and access is installed under the manufactured home. It is an intent of the criteria to ensure that Class A manufactured home, when installed, shall substantially the appearance of an on-site, conventionally built single family dwelling. The purpose of this home is consistent with the ordinance definition of a Class A manufactured home. The RA district does allow for this under your permitted use table by special use permit. Appearance standards ensure compatibility with surrounding residential development, and no adverse impacts on public health or safety are anticipated for this home to be installed. It is a staff recommendation that the special use permit be approved with the condition that ordinance requires for the Class A manufactured home, including masonry underpinning, and are not prior to issuing the, I'm all tongue-tied. It is our recommendation that you approve this and that they also abide by the underpinning requirements as by the zoning, which would be on your special use permit. The, Mr. and Ms. Mr. Ian and Cali were not able to be with us this evening. They did have a representative that was supposed to be present, but they canceled at the last minute. So, they have provided the, layout for the house. It is a Clayton home, and the floor plan, very similar to what we previously saw. They do have to meet their setback requirements, same as, RA housing, that would be stick built. So, if there's any questions I can answer for you at this time, I'd be glad to.
I have a question. I can't tell from this picture.
Mhm.
What type of foundation are they planning to do? Is it brick?
So that can be determined. It can be brick. I think it says, by our ordinance, it has to be masonry.
Masonry, curtain, or brick?
Right. Permanent masonry curtain wall or foundation. So, I'm not sure if they're gonna do brick or stone, but it would be one or the other. It can't be just, the typical
Vinyl
vinyl.
underpinning.
It has to be a permanent.
FHA will allow vinyl underpinning, so that's why I wanted to make sure for clarification, because I could not tell on this one. The other
Okay.
one, it was a little bit more clear.
This one, the photo on that one, it looks like it's, I guess it's what's provided by the, manufacturer. And it looks like it's setting closer to the ground, but it would have to be by the zoning ordinance requires a masonry foundation.
So in the event it is approved, just please make sure that you
I will.
clarify that with them.
I will. Okay, any questions that you guys have for staff? You can come back to it if you need to. All right, this time, I've got two people who would like to speak.
Mr. Floyd?
Let's go on first.
Okay,
Okay.
hello, Garner.
Can I ask a question as far as the ownership? I noticed that by my.
Just real, if you would state your
I'm
name and
sorry,
address.
I should have done that first.
That's fine.
Lowe Garner, 204 Sturdivant Road, versus James Lowe Garner, and also be representing Mary Rose Glover, 454 Tamworth Drive, who's another adjacent owner. She's my mother-in-law, and I'm a keeper for her, and also a POA for her, and also my wife, the same residence as I am. The first question I had is the persons that are doing the permit are actually a LLC, which provides housing that puts people in the houses. It's not the actual end owner, so I don't know if that needs to be addressed at this time. And I've been at my residence for about 40 years now, and on our street, there are no double wides at this time. This would be directly affecting me because it would be right beside me. As far as the land that there's been some flags put up directly right beside it. I mean, they're in compliance with where they're what they're supposed to be doing. I've seen all their application, sounds good and everything. The only thing is this would be the only double wide on the street, and east of that property, I'm a part of the Clark Acres subdivision, my lot, and then there's there's a road, Tamworth Drive, and then there's 3 other residential lots that are vacant that go to Old Camp Road, which are also part of Clark Acres, which is a restricted subdivision, which I think the bylaws have been expired by now, but it's still, I guess, a different zone. Also, as my mother-in-law suggested that, it's not personal preference, but also as far as the aesthetics, this would be a little bit diversifying away from the normal stick belt house would be. And I just wanted to place that before the board, and I'll just allow Angie to go next. I thank you for your time, and that's the only, as far as the staff analysis, appearance standards, it says here, compatibility with surrounding residential development. It's as far as that goes, I don't think it would be compatible with the surrounding residential development because there's, is it 4 or 5 lots that are adjacent that are a part of the, Park Acres, I believe? I know they're different zoning, and I know this is RA, but, it's also, like I said, I don't think it would be compatible with the surrounding, residential development. And since Sturdivant Road's such a small road, and the residents east of their, land is also housed, there's an old hosiery mill, and then there's, the rest of the road to Highway 47 is the residential stick-built brick houses and stick-built houses, so. And I'm not aware of any other, manufactured homes on the road, so that is, where I stand with and that's the only thing I could say as far as the impact of it is the compatibility of the houses on that road, so. Like again, thank you for your time. Any questions?
Any questions for Mr. Garner?
Do you want for me to address any of that?
Sure.
So as far as the applicant being an LLC, it's no different than someone who would be a contractor who's asking for a special use permit in order to build a home. So these people are potentially going to build this for resale or for a rental property, I'm not sure. They're just asking for the special use permit to place the home there. So it would be no different than a contractor doing the same. As far as the Clark Acres subdivision, there is not an HOA, and if there was, it has expired because it's not been maintained on a yearly basis, so there are no restrictions for this. This property is not part of the Clark Acres subdivision. It is outside of that jurisdiction, and it is zoned differently.
I'm sorry, I did state that, didn't I?
How far does ETJ go out on Old Camp Road?
To Old Camp.
Yeah, from say, where we're at now, the city limits, how far does ETJ go out? Just as curiosity now.
You go to,
Does it get past the
Sturdivant.
cemetery?
no, we do not go down that far.
It's up at the top of the hill near Jack Brooks' house, or I was told that.
Right,
The
it's,
city limits,
it's Sturdivant Road.
Oh, I live in ETJ.
Yeah, it runs down to Sturdivant, and I wanna think the first house on the right is in our ETJ, but after that it's not. So
Okay.
it doesn't go as far as the cemetery by any means.
Okay.
It's the
She talked about
extraterritorial
non-monument
jurisdiction.
system.
It's not extraterritorial jurisdiction,
Mhm.
so it's not within the town limits, but it's
Right.
still under our zoning requirements.
So,
Okay.
so it doesn't go beyond as far as
She's talking about-
Steve
So in other
Harris's
words,
house.
I'm not in the town limits, but I still have to,
But you would still be in the
Right.
ETJ.
So-
I have to go as far
Meyer.
as 593.
I can bring the map over if you guys want to
I
look
was
at
just
it.
curious.
Okay.
I mean, if we're saying this is part of the ETJ and it's on Sturdivant Road,
So this
we know that
property,
it has to go as far as Sturdivant Road,
Yes.
correct?
it does, and, it does take in all of Sturdivant.
Ms. Floyd, if you'd like to state your name and address.
okay. I'm Angela Robbins Floyd, and I own the property at 822 Old Camp Road. I have over 13 acres there, and a lot of it is across the street from this request. I own land all the way up to the power plant. When David and I sold the Collins people this land, they told us that they planned to build a nice home up there and that they were going to move to Denton, which was fine. I mean, we needed a new couple and somebody in our neighborhood. So now they want to sell this narrow strip that goes down the side of the land that we sold them right at their driveway that they have already put in there, and between that and Lowe's house. We don't, like he stated, we don't have any mobile homes in our neighborhood. Everyone that's been living there has lived there for quite a while. My research says that sometimes mobile homes will have a negative effect on property values. Maintenance issues, neglect can depress the surrounding properties. And you all know what I'm talking about with some mobile homes. We own the land across the street that the mobile home is going to be put on, and we don't know who's going to own it. Now, is this going to lessen the value of my property across the street if I decide to sell it someday? So, I request that you consider this, and I want to protest the rezoning and hope that the council will make the decision to reject this request. Thank you.
So Ms. Floyd,
Yes.
you're in the brick home, correct?
Yes, I have the
brick
one,
home right across the
Right.
street of Margaret Harris.
yes. The old White House on the corner was David's mother and daddy's house. And we did sell that. Yeah, the rest of it is ours. All the way over to the Pierces.
Okay.
Yeah.
Angel, do we not have a double wide there on Old Camp Road, right near all this?
No, not that I know of.
Point of order, again, you have to have actual evidence, no opinion.
It's not opinion, it's-
No, that's not what I'm saying. But you may wanna ask if any appraisals have been done, suggesting any differences in values or et cetera.
Ms. Floyd, have you had an appraisal done that would factually show that, what your home's appraised at now versus their opinion is?
Just got the new property tax thing from the county.
But as far as an appraisal, like from a real estate person to say,
From a real estate person?
Yeah.
No.
Okay.
No, the only thing we had done was, Pansy Hunt, we gave her the 9.5 acres or whatever it was for her to sell. Yeah.
okay, thank you.
Any more questions?
No, ma'am.
If I could do a point of clarification, you asked about your ETJ, and it does take in your cemetery, so it's just past the cemetery. I'll bring this up so you guys can see it.
So
This
it's
is
a
still
creek.
1 mile out, Andrew. It used to be, but they've changed it, you know, when we annexed in some of it, it's not necessarily, especially south part of town. But this area would be more in that area than a mile out. But, Sturdivant Road runs here, and this parcel is right there, beside of the purple area, which is under special conditional use permit already for the mill.
That's what I'm trying to.
Ma'am, may I ask you a question?
Yes,
So you originally owned the property and sold it to the folks that are wanting to sell this strip now, correct?
right, we sold it to the Collins, yes.
When you sold it to the Collins, did you place any deed restrictions that would prevent any manufactured homes?
Not that I know of, we weren't asked to. They told us they were going to build a house up there and that they were going to move to Denton.
Thank you.
Any other questions from Ms. Floyd? Do the board members see a need for a condition or conditions to be placed upon the applicant in the event the application is granted, and what such conditions might be? The board has now received all evidence and testimony. The hearing is now closed, and the board must consider the evidence and vote on the matter. Board members, does any board member wish to discuss what we have heard and received? If the board has no further questions or need for discussion, we must now begin the voting process on the finding standards As a reminder to the board and those in attendance, North Carolina general statutes and our town zoning ordinance requires a 4/5 majority vote in favor of the applicant on all 5 standards. In order for the applicant's special use permit request to be approved, we have 4 voting members in attendance. A successful motion on each standard requires at least 4 affirmative votes.
Just said that, no. Send it right back to me.
I'm gonna go back to the meeting.
Standard number 1. With regard to standard number 1, the use will not materially endanger the public health or safety if located where proposed and developed according to the plan as submitted and approved. May I have a motion to approve or deny standard number 1?
I make a motion to approve standard 1. If I could find another format. Will not materially endanger the health or public safety. Class A manufacturing must meet HUD's construction standards. Installation must comply with Department of Revenue, or Department of Insurance setup requirements, and permanent masonry foundation removal of transport equipment is required.
Do I have a second?
I'll second.
Any need for further discussion? All in favor? Standard 1 passes with a vote of 4-0. With regard to standard number 2, the use meets all required conditions and specifications of the permit. May I have a motion to approve or deny standard number 2?
I make a motion to approve standard number 2. Minimum of 1,200 square feet with pitch of 3.5 to 12, 6-inch E projection, exterior siding comparable to site-built homes, removal of hitch wheels, axles, 10-use permanent masonry curtain wall, and compliance with Department of Insurance setup standards.
Do I have a second?
I'll second.
Any need for further discussion? All in favor? Aye. Standard number 2 passes with a vote of 4-0. With regard to standard number 3, the use will not subsequently injure the value of adjoining or abutting property, or the use is a public necessity. May I have a motion to approve or deny standard number 3?
I make a motion to deny standard number 3, Class A homes are designed to resemble site-built dwellings, masonry underpinning, and residential grade material reduce visual impact.
So the evidence, point of clarification, the evidence you just gave was in support of approving it. So you're gonna have to give factual evidence to deny it.
Give a reason for denial.
I just, okay, I
It's gotta be factual.
understand. Just call it good. I can't give a factual. I live in the area. I feel for what Ms. Floyd has said. Factually, there is nothing. Gut feeling is just gut feeling.
Unfortunately, you can't.
I understand.
It's a quasi-judicial
I
hearing.
understand. Gut
So
feeling
it's
means
gotta be
nothing.
factual.
So what do we do if we just don't make a motion? Where do we go?
Somebody has to make a motion to approve or deny based on the evidence presented.
And then you can vote to oppose. Correct? I'll make a motion to approve standard number 3, the use will not substantially injure the value of adjoining property or the use as a public necessity. Evidence given, Class A homes are designed to resemble site-built dwellings, and the masonry underpinning and residential grade materials reduce visual impact. Do I have a second?
I'll second.
Any need for further discussion? All in favor?
No.
Standard number 3 did not pass with a vote of 3-1. Correct.
Is that, is 4/5 vote? So we have 4 present.
But don't you have to have all 4?
Still have to have 4/5 of the board.
Is that right? I mean, before the, requires 4/5 of vote, majority vote in favor of.
That's catchy.
No, but I will do the math.
Basically, 75% versus
I
80%.
think it's two separate things, like the 4/5 that you're talking about. You have 4/5 here, so you can hold the hearing, but the 4/5 you're talking about is the approval, right?
No, so a quarter on the whole the meeting, but then it does, in what was read for the hearing, it states that as a reminder, the board and those in attendance, North Carolina General Statute, the town zoning ordinance requires a 4/5 majority vote in favor of the applicant on standards in which, in order for the applicant special use permit to be.
It's gonna have to be all 4, it's gotta be 80%, and that's 3.2 out of 4, so you gotta have 82, so you're gonna have to have all 4.
Okay, just making
That's
sure
what
for
ChatGPT
clarification.
said too.
Okay, well, there you go, it's right this time.
I was just making sure for clarification.
Yeah. But I want you to continue on with finding 4.
With regard to standard 4, the location and character of the use is developed according to the plan as submitted and approved, will be in harmony with the area in which it is to be located, and in general conformity with the plan of the development of the town and its envisions and environs. May I have a motion to approve or deny standard number 4? I'll make the motion to approve standard number 4, that the location and character of the use will be in harmony with the area and in general conformity with the town's plans. Evidence being Class A manufacturers' homes are permitted by special use permit in RA. Appearance standards ensure compatibility with surrounding homes. Do I have a second?
I'll second.
Any need for further discussion? All in favor? Standard number 4 is denied with a vote of 3-1. After voting on all 5 standards for the special use permit request, the board approved general standard number 1 with a vote of 4-0, approved general standard number 2 with a vote of 4-0, denied general standard number 3 with a vote of 3-1, denied general standard number 4 with a vote of 3-1. From a review of the votes of the board, at least one of the special use permit standards was not approved in favor of the applicant. Denying general standard number 3 and denying general standard number 4, and as such, in accordance with the town zoning ordinance and North Carolina law, we must deny the special use permit request. Do I have a motion for denial of the special use permit?
So now I can,
Yeah, it was based
I
on.
motion that we deny the special use permit.
Do I have a second?
I'll second.
All in favor? All opposed, 0. The results are, the special use permit is denied with a vote of 4-0.
Angel, in the event that the applicant wishes to appeal, they have 30 days to appeal to the, District Superior Court, not District, Davidson County Superior Court. And it's 30 days from the date they receive the written decision.
May I address the item 3, just as a general question? If you did your research on the effect and the values, was that on a real estate website?
Yeah, I think it was.
So unfortunately, under North Carolina law, it would have to be an appraiser.
That's why I was wanting to.
Yeah.
No, I just went on the computer and started looking.
It would have to be a North Carolina residential appraiser, so in the event that it would be appealed and anyone wanted to offer testimony against it, they would need an appraiser to give expert testimony that it would diminish the value.
So item 4, how many of the items have to pass to
4.
the whole thing?
All 4, yeah.
Okay,
So it was denied on 2.
okay.
Okay.
Thank you.
So they have a right to appeal.
They do. They will have a right to appeal, and that will go to the Davidson County Superior Court.
Right.
If they have contingency sale,
Do
there's
I need to get my land appraised?
So if they make that decision to appeal that, then they would they have, can they be a witness there as well? Or is this, how does that work?
It would be a de novo, so they could go, and if they have standing, then they could offer testimony. So it's one of those things. But also, aside from that, just as a general information, if you sell real estate, you have the right to put restrictions on that real estate that you sell when you sell it. So if you're adamantly opposed to manufactured homes, not stick-built homes, please put restrictions on it when you sell it.
See, I didn't know that at the time. I never thought that Connors would sell it after talking to them, and, you know, they were gonna build a
Circumstances
house.
Yeah.
change.
Yes, I know.
They're
I
young
know.
too. They're young too.
Yeah.
So
Yeah.
could she, if she wishes to speak and move forward, suggested that she get an appraisal, what the impact would be on
I
her?
would suggest that in the event they file an appeal, that you talk to an attorney and get some advice on what you need to do.
Oh, okay.
Yeah.
We can do that.
Okay, all right, thank you guys for being here.
Thanks.
this evening.
Thank you.
Thank everyone for the time.
Yep. Thank you for listening to us.
That's our job.
So,
Thanks for coming out.
our last meeting, I had, education training set up, and we were gonna start reviewing our modules, and, I didn't have a quorum, so I forgot my computer today, because my laptop died here at work, and, I don't have it set up, so we'll do that at the next meeting, just start working through those modules that we've got for
Have you
everybody.
sent me the full 160D in the Word format? Do you know?
The rewrite for our zoning, I don't know that I have forwarded that to you, so I will
Okay.
send that,
Because I've made notes on what I think needs to be changed, I need to compare it to what
Okay.
you've got.
I will. So what Missy's talking about, you know, we've discovered that there's some discrepancies in our zoning ordinance after the rewrite from the 160D. So once that is compiled, hopefully by next month, we can bring that to you guys to start that review, because once, the review's done first by the Planning and Zoning Board, recommendations are then made to the Board of Commissioners for them to review it. So, we are also, looking at your subdivision ordinance, and a lot of that has changed as well with the 160D rewrite. And, you know, we've kind of started going through chapter and verse and everything, one line at a time. And, being that we have so much to change, it's gonna be a complete rewrite on that as well. But, lot to do in the next couple months as far as review. We'll get through it, okay? So what we'll do is try to present it to you, give you the next month to look over it, come back with any questions or concerns, but everything will be directed back to whatever the state general statute allows us to do. Any questions that you guys have for us?
Have a motion for adjournment.
Make a motion to adjourn.
Second. All in favor?